Abusia Manhyia South MP I friend lawyer Bafuwa Andra Ebeto just a President Mahama suspended a Chief Justice pending the investigation over those petitions now President Mahama received said this Chief Justice Ayemi Boni Binti or Shushemono. This lawyer Bafuwa and I'm everyone from one radio station to the another, one TV station to the another. And then more can say President Mahama any to me as or suspended a Chief Justice Tokono na ono lawyer Bafuwa ewuano or the assembly court akwa challenge President Mahama na any simple brain no more keka na no ene lawyer Edudzi Tamakloe ekopie ewo TV3 eno mubusa ni say what in some lawyer Bafuwa anamo akeka say your friends your President Mahama need to me say or suspend the Chief Justice in the constitution emrebian who was President Mahama emrebian who excess President Mahama betimi suspend the Chief Justice na no lawyer Edudzi Tamakloe si nyankopon ma na botre because nyame ama na botre asema obeka no wanhwe ya enye lawyer Bafuwa ewuade na wanhwe ya no akonya ne kasetia na de nsem bebre aba timi nso obi ama yankwa nsem a ye lawyer Edudzi Tamakloe ekopie mu TV3 no odi tu dwa mom yenhwe.
As a legal practitioner, having followed this as well, Edudzi Tamakloe, would you say that the minority are right, that President John Dramani Mahama is on a political vendetta, a coup, so to speak, flouting due regulations, and that power of discretion has been exercised wrongly?
Okay, so once again, I just want to thank your viewers for this opportunity. The comments from the MPP micro minority and the MPP as a whole is a calculated attempt to politicize an obvious constitutional duty that President Mahama is performing. But the reason why you'd expect that the MPP would want to politicize this obvious constitutional duty being performed by President Mahama is because of a certain fear, a certain, I'll call it, panic. Because if not, has President John Dramani Mahama done anything today outside the scope of the 1992 Constitution?
How do you mean, Edudzi?
The answer is no. President Mahama has not done anything outside what the Constitution requires him to do. As we speak, we have only one President of the Republic. President John Dramani Mahama does not share that position with Afenyo Makin. He doesn't share that position with Atachia. He doesn't share that position with lawyer Dakum or Bafuwa. There is only one President of the Republic at any time. And today, it is President John Dramani Mahama. Article 146 of the 1992 Constitution is clear as to the procedure, what ought to be done. Has President Mahama done something contrary to what the Constitution stipulates? No. Now, the 1992 Constitution envisaged that we'll get to this point. And let me tell you this. You see, in the past, in drafting this 1992 Constitution, it mirrors our history. Because Osajifo Dr. Kwame Nkrumah, the record says that when he was not happy with the acquittal of Tawi Adamafio and co, decided to remove judges that he was not happy with. And so when we're crafting the 1992 Constitution, we place in it elaborate procedures if there is an intention to remove a superior court judges. Thankfully, post-1992, we have the benefit of how judges have been removed. Superior court judges from high court to Supreme Court judges, there is a process for their removal. In fact, based on the announced investigation, Tiger Eye or something, some high court judges were removed. Incidentally, it was under President Mahama, if you remember. Now you see, if you read the Constitution, Article 146, it says, a justice of the Superior Court or chairman of so and so shall not be removed from office except for stated misbehavior, incompetence, or grounds of inability. Now listen, this way is even more profound. he says that you cannot remove a justice of the Superior Court except in accordance with the procedure specified in this article. So you notice that all the MPP lawyers combined, so far none of them is able to say that President Mahama had breached any provision of the Constitution. Because you see, what distinguishes a good leader from others is who his advisors are. President Mahama had the benefit of having a very matured former Attorney General as his legal counsel in the person of Marietta Brew. Now, with the benefit of such sound legal advice, together with the learned Attorney General and the lawyers he has, he had decided to stick to what the Constitution says. It's not an amateur. No. So what President Mahama has done is to follow the strictures of the Constitution. Now, Article 146(3) says, if the President receives a petition for the removal of a justice of the other than the Chief Justice, and in this case, it's the Chief Justice. So you notice that in the Constitution, there is only one person to perform that function. And that person is the President. Now, our friends in the MPP are saying that when the people or the petitioners had their petition or grounds, President Mahama ought to have shut the Jubilee House and block the airspace, block every way, so that they cannot come there and present the petition to him. But you see, there's something unique about President Mahama. Consistency. Let me tell you this. MPP member called Richard Nyama, you know him.
Yeah, I know him.
He even contested the MPP primaries, I think in Pandai.
Yeah.
Somewhere around 2015, 2014. Brought a petition for the removal of an appointee of President Mahama in the person of Madame Vivian Loretta Lamte, the then Shrad boss. What did President Mahama say? He didn't say, oh, this is an MPP person bringing a petition to have my own appointee removed, and so I will close my door. No. He took possession of the petition from Richard Nyama, went through the process, and eventually, you know what eventually happened? A committee, just as this committee, was set up by the then Chief Justice, that's George Nawood. And this is what the letter says. That's the 5th January 2015. Mr. Richard Nyama, petition for the removal from office of the Commissioner for the Commission on Human Rights and Administrative Justice under Article 146. So President Mahama, consistent with his previous conduct, where an MPP person brought a petition to have the then Shrad board removed, complied with the Constitution. And listen, when everything was done, the then Chief Justice put up a 5-member committee comprising His Lordship Justice Eni Yeboah, His Lordship Justice Bennett, Her Ladyship Justice Mariama Owusu, one Edwin Barnes, and Brigadier General Hussein Idrisu. So it was this 5-member committee that investigated the complaint against Madame Loretta Lamte. And in fact, the lawyer for Richard Nyama at that time was my own senior Samson Ladi Ayeneni. They went through the process, gave their recommendation, and President Mahama, pursuant to Article 146, caused to be removed.
What's your point with this?
The point I am making is that President Mahama has demonstrated consistency and fidelity to the law. President Mahama has not done anything. Now let's juxtapose that by parity of reasoning to the instant petition. We are being told that 3 petitions came relative to Her Ladyship, the Chief Justice. When President Mahama received the petition, right, do you know what he did? His communication minister, information minister, the Honorable Felix Kwachi, put out in the public that the President is in receipt of this petition for the removal of Her Ladyship. Pursuant to that, he gave an indication that the Council of State will be informed so that the Council together with him will perform the constitutional responsibility when said petitions are removed. Subsequent to that, the MPP, led by the Member of Parliament for Tafo Pankrono, Vincent,
also a legal practitioner,
and the former Attorney General, Godfrey Adame, rushed to the Supreme Court. Relief one had to do with the fact that her ladyship, the Chief Justice, was not notified. And for some of us, we say, how did Asefua become aware that her ladyship was not notified? Was she in communication with her ladyship?
How did you deduce that?
No, because Relief one,
put the cat before the horse?
No, Relief one. Not long ago, there was a letter from her ladyship, the Chief Justice, copying the Association of Judges and Magistrates and some other people, requesting from the President copies of the petition for her response. President John Dramani Mahama properly advised, proceeded. In fact, her ladyship wanted 7 days. President Mahama says, no, I will even give you 10 days so that you can prepare your whatever response you have adequately. My information shows that her ladyship didn't just responded to the petition. She actually filed a supplementary response. Now, having filed a response and a supplement, clearly what that suggests is that even per her own conduct, is that she had joined issues with the petitioners. So usually in law, like we always say in the judicial court process, when you join issues with maybe a plaintiff or whatever, you are simply saying that this matter should be set down for trial because there are controversies. That is the only responsibility of President Mahama at this stage. To just demonstrate that there are controversy. And so when the petition came and she got the opportunity to respond, she put together response and documents. That is not the responsibility of President Mahama. It is not for President Mahama to interrogate those documents. All President Mahama is supposed to do at this stage is to make a determination that is the petition frivolous or not. How can a frivolous petition get a response and a supplementary response with documents attached? So at this point, all President Mahama had done together with the Council of State is to say that, look, this is not frivolous. And to the extent that it is not frivolous, I am setting up together with the Council of State, having been properly consulted, a situation where, yes, a situation where they are now going to investigate the merit or otherwise. At this point, President Mahama has not said her ladyship, the Chief Justice, is guilty. All he said is that the petition had met a certain minimum threshold. It is gone beyond frivolity. So for that matter, let a panel that the Constitution itself says should be done. Now, with His Lordship Justice Gabriel Puaman, Justice Asiedu, one from the military.
As the lady by Dalubu.
Yes. Then there's a professor, and then Domolevo. Domolevo has distinguished himself in this country. Very respected person.
And you're saying particularly because there could be content about misappropriation of funds or...
No, from all indication, the understanding is that portions of it relates to the Auditor General and his findings. And to the extent, who better appreciate the issues of audit than the former Auditor General? And so, as we speak now, what President John Dramani Mahama had done is basically to just comply with the 1992 Constitution. But you see...
Just to make this intervention, while that is complying with the tenets of the 1992 Constitution, I've heard the Member of Parliament for Manhyia Sound, who is also a legal practitioner, by the way, Nana J. Bafwewa, who insists that discretionary power that the president exercises or is exercising, perhaps he shouldn't have been exercising that with other constitutional instruments in place, etc. Even though it's been exercised also before by former presidents.
You see.
How is that a justification?
You see.
Or not?
You see, sometimes people like Bafwewa and others betray a certain lack of, what shall I say? I want to be careful with my choice of word.
I don't understand. You're saying they're exhibiting double standards?
No, I think they have gone beyond the issue of double standard. Selective amnesia.
You've listened to him, haven't you?
Desperate blindness. You understand? Bafewa has been a lawyer in this country. On what basis did President Mahama remove, what shall I say, Madam Lamte? On what basis did Nana Dankwa Akufo-Addo remove Charlotte Osei? But you see, they want to throw dust into the eyes of Ghanaians. Article 146(11) says, quote, the president may at any time revoke a suspension under this article. More importantly, if you look at the federal constitutional provisions, it says that where a petition has been referred to the committee, the president may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State, by a warrant signed by him, suspend the Chief Justice. Complete. That's what the law says.
And that's where we are currently.
And that is where we are.
Why is that important for the suspension to happen, Edudzi Tamakloe?
No, because the Constitution envisaged that should happen. There is a possibility of that happening. So the Constitution is provided for it.
So that...
And President Mahama, as we speak, has just complied with that constitutional provision without more. Now, they confuse something. You see, the Supreme Court, in the case of Ransford France and the Attorney General, where the Constitution in Article 47 says that the Electoral Commission may create new constituencies, you understand, and now came back to Article 296 to say that if you look at Article 296, the constitutional provision, and it's important that I reference it because it's public education. If you look at Article 296, and this is where they want to confuse people by saying that President Mahama has done something contrary. Okay, here. It says, listen, where in this constitution or any other law, discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. So far, President Mahama has said, look, give her the petition. Let her file her response. She even filed a supplement. So how was that capriciously done? He said, the exercise of that discretionary power shall not be arbitrary, capricious, biased, either by resentment. What has President Mahama done? The petitioners are not NDC members. In fact, in the case of Loretta, it was a known MPP person, including Frank Anodon-Pre. President Mahama didn't say go away. He took it, acted on it, and even removed his own appointee. Now, this is where it gets interesting. He says, quote, where the person or authority is not a judge or other judicial officer, there shall be published a constitutional instrument or a statutory instrument, regulation, that are not inconsistent with the provision of this constitution. This is where they raise the issue about President Mahama. And that because the constitutional provision on suspension says the president may, it means that the president they should have been published a CI or a statutory instrument to regulate how that may function appearing in Article 146 should be. No. You see, so the Supreme Court clarified that matter in Ransford France. Because the conversation in Ransford France was that because the EC had not brought up an instrument to show how to create new constituency, the new constituencies that were created in 2012, everything done under it were unconstitutional. In the reasoning of His Lordship Justice Databa then raised the issue of nuclear meltdown and said that no, that is not the reasoning. If not, any time the president wants to exercise a discretion, it means that he must come up with a constitutional instrument. That is how Ransford France in that matter, the new constituencies in 2012 were created. Because they wanted that entire CI set aside. And I remember it was my lecturer in company law, Jogati, who was the lawyer for Ransford France in that matter. And so I think it must be very clear that the Supreme Court itself has spoken authoritatively on this matter. It doesn't work that way. If not, any time the president wants to exercise a discretion, he would be required to provide a constitutional instrument to guide that. And that is where His Lordship Justice Datiba said, no, if that is the case, even the functioning of executive power will grind to a halt. At this point, there is only one person who can exercise that power under Article 146, and that person is President John Dramani Mahama. So everything that has been done so far is within the confines of the 1992 Constitution.
Solo, in the court of public